Two recent Israeli Supreme Court decisions have intensified the already fiery conflict between Israel's judiciary and political branches. So what sets these rulings apart and what lies ahead? That's what we're talking about today. I'm Aylana Meisel, Executive Director of the Israel Law and Liberty Forum, and this is Basic Law. Welcome to the show. Now, before we dive in, I want to acknowledge two tragic events since our last recording. The first is the murder of Yaron Lashinsky and Sarah Milgram in a terror attack in Washington, D.C., and the second is the passing of 2-week-old Ravid Chaim Gez, son of Tzayela Gez, who was also murdered by terrorists in Judea and Samaria. Now, the murders in Washington mark yet another stark turning point for the American Jewish community in recognizing and in responding to the growing threats our people face. Basic Law will continue covering legal responses needed to protect Jews abroad and to deter and punish their attackers. As for the loss in Israel, we extend our deepest condolences to the Gez family and mourn with them and the entire nation. Now, today's discussion is no less than about the future of the State of Israel, not due to external threats, but because of rising internal tension over law and governance. Critics argue that the court's recent decisions involving the appointments of the Shin director and the head of the Civil Service Commission have further undermined Israel's elected government. Some even claim that this marks a major, even final step in displacing the political branches, with national security and broad policy implications at stake. So, what do these rulings say about Israel today, and what do they mean for our tomorrow? We're joined by advocate Yonatan Green, former research fellow at Georgetown Law's Center for the Constitution, and my co-founder at the Israel Law and Liberty Forum. Yonatan, welcome.
Hi there.
Thank you for joining us. Now, we're tackling complex legal and political terrain today, and it's important to stress that all views expressed are personal, and they're not those of the Forum. The Forum is an educational initiative promoting conservative and classical liberal legal leadership through publications and debates in Hebrew that foster dialogue across ideological lines. As such, we draw a clear line between our personal opinions and the Forum's work. And now, with that said, Yonatan, tell us a bit more about your recent and past work.
Well, as you mentioned, I'm currently a fellow at the Georgetown University Center for the Constitution. I've had all kinds of sort of enjoyable projects there, but my main current project is that I'm writing a book on the Israeli legal system for a general audience. Unfortunately, it's not out yet, so I can't send you all to go order it on Amazon, but you'll surely be one of the first to know, both you, Aylana, and you, the audience of Basic Law Podcast.
We'll make sure of that. So listen, let's examine these two decisions, especially regarding the one relating to the Shin director. We've done a few episodes on this before. The audience, I think, knows the case, and it's obviously the sexier of the two. But you basically argue that they both mark a procedural and substantive shift in the court's power struggle with the elected government. Okay? So explain why.
Absolutely. So I think first, just for a moment, it's worth diving into the specifics of each of these rulings. And, we won't do too much of a deep dive.
Sure.
Into the legal intricacies, but it's worth sort of giving a clear view of what's happening. So in the Shabak case, or the Shin case, Israelis call the Shin the security service, the Shabak, the sort of Israeli internal security service, the FBI, or whatever you want to call it. In the Shabak case, I'll go back. I'll return in a moment to the sort of the whole issue surrounding mootness and the panel composition and the standing in that case, because they're also kind of interesting. But what happened here is that you have a very, very clear statutory framework, which is completely unambiguous, and I'll read it for you. I have it here for a moment. In Hebrew, it's Rosh Shirut HaBitakon HaKlali, the head of the Shin Bet, the Shabak, Yemune Bidei HaMemshala Lefi Atzaat Rosh Memshala, will be appointed by the government. The government means like the cabinet, the collegiate body, by government resolution according to Prime Minister's proposal. And then a couple of sections down, it says that I won't read the Hebrew. It says the government is the government may terminate the service of the head of the Shabak before it ends. Period. So that's the statutory framework. It's extremely straightforward. The legislative history also is unequivocal about the considerations behind legislating it in that way, I think fairly obvious. We don't have to sort of explain the rationale. It's fairly clear in most democratic countries why the head of your secret police, what is essentially the state's secret police, needs to be subject to civilian control, to direct elected democratic control. And the most meaningful sense in any democracy of that kind of control is the power to hire and to fire, a phrase that we might return to. So as you know, as you've covered, the government essentially resolved to dismiss Ronen Bar, the current head of the Shin Bet, the head who was the Shin, the head of the Shin Bet during the October 7th attacks and in the lead up to the October 7th attacks. This was challenged in court, and finally, after something of an ordeal, the court has recently issued its ruling. This was a 3-member panel. The ruling was a majority of 2 versus 1, and the court essentially issued the court ruled that the dismissal was unlawful for a variety of reasons. It spoke about procedural flaws, spoke about a lack of a factual basis and a lack of a hearing, and also noted that the prime minister was under some kind of conflict of interest because of the Shin Bet's investigations into Qatari contacts of people on the prime minister's staff, et cetera, et cetera. In a moment, we'll go into why this is so extreme and really is an escalation from previous things that we've seen. I will note just for a moment 2 interesting things which I think are, also illuminate this case a little bit. One is that the ruling was entirely moot because the government had essentially rescinded its resolution. It had canceled its dismissal of Ronen Bar. And typically in any other country, that would be the end of the petition. The petitioners rescind their petition. It's over. There's no government decision to challenge. There's no operative remedy for the court to give. The court is not quashing any government order because no such order exists. And yet the court insisted, when I say the court, I mean acting Chief Justice or disputed Chief Justice Yitzhak Amit and Justice Daphne Barak Erez decided or insisted to push on with this ruling, what they call a principled ruling or a theoretical ruling, despite its mootness.
Yeah,
And another interesting point here is the lack of standing. Yeah, go ahead.
Has that ever happened before in Israeli law?
It has happened occasionally. It's very unusual. In principle, there's no difference between this and the court simply issuing a sort of advisory opinion, a binding advisory opinion, before any decision is taken. Meaning this is the same thing. It's as if no decision has been taken and the court just does this. It is extremely unusual, not unheard of. It has happened in a few rare instances before where the decision has become moot, and typically the legal counsel to the government, what some people call the Attorney General, insists on receiving some kind of a decision. It happened with Minister Amir Ohana in a case that had to do with COVID vaccines for inmates, but it is extremely unusual.
Okay.
I'll add just one point about the standing. Ronen Bar, the current head of the Shin Bet, was not a petitioner here. He did not petition at all. And in Israel's sort of completely loony rules on standing, anybody has standing. Anybody can sue. Anybody can petition the court for any reason. They don't have to show any sort of individual, personalized grievance, etc. However, one consistent exception has been that typically if there's a clear aggrieved party, then that party has to sue. And if that party doesn't sue, then no one else can sue in their name. Here, once again, the court just kind of throws that out the window, doesn't really address it at all, and just sort of barrels on with this ruling. I'm going to put that aside for a moment because that's what this ruling looks like, and we'll come back to it in a moment, and talk very, very briefly about the Civil Service Commission ruling. So this is another ruling that came out around the same time. A lot of people, I think, are sort of categorizing these together as a, kind of as a pair. And it does make sense. There are some important differences between them, but they both involve the government's ability to appoint or dismiss some of the most high-profile public servants in the Israeli government. And also, interestingly, they're given by the same panel, by the same judicial panel, by Justice Amit, Justice Daphne Barak Erez, and Justice Solberg. Now, I'll push pause on that for a second. It's worth just saying one more thing about the panels. In Israel, the Chief Justice essentially decides the panel composition of Supreme Court cases. It's a little bit more complicated than that, but basically the court very rarely sits en banc, the entire 15 judges. It's virtually never happened. It happened only once ever. This Chief Justice is essentially the one who decides the panel composition. And this is a very unusual panel composition because it's only 3 justices for very high-profile cases. Typically, a high-profile case like this will have an expanded panel of 5, 7, 9 justices, whatever it is. And the reason behind this is very obvious and transparent to everybody. This is the only conceivable composition which Chief Justice Amit could create, which gives him an activist, or what I call a judicial supremacist majority. So this is the only way where Justice Amit could engineer a majority that would give him the outcomes that he wants here, versus virtually any other panel composition that is currently available to Justice Amit would most likely have rendered the opposite outcome. So that's just kind of another thing to put in the back of your head. One day when Basic Law Podcast has an episode on panel composition or the Chief Justice power, then hopefully you come back to this. So back to the Civil Service Commission, and then we can dive in a little bit more seriously into this. So the history here is way more convoluted and complicated, but I'll sort of give the Cliff Notes version to this. Civil Service Commissioner is a very, very senior bureaucrat, essentially, in charge of the entire apparatus of government employment and employees, et cetera. He's essentially the bureaucrat in charge of all the entire bureaucracy in some senses. Again, the statutory framework is extremely straightforward, cannot be more clear, okay? The government shall appoint a civil service commissioner. Meaning his appointment does not require a competitive process or some kind of bidding process or whatever it is. Does not require, there are all kinds of other appointments in Israel that do require a sort of formal competitive process where there are multiple candidates and where there are all kinds of rules, etc. Since the founding of the state, every single civil service commissioner has been appointed by direct resolution of the government, period, no exception. This has always been the case. In 1993, the government itself made some decision that it was going to add one more layer to that, in the sense that they would nominate someone, and then they had an ad hoc committee that they appointed to, which would approve or which would vet this appointee, but it was still a government appointee. Last chapter in this, and then we're going back to today. In 2011, there was a petition against this arrangement, a major petition in the Supreme Court, where the petitioners argued that the government had to adopt some kind of competitive bidding process or some kind of, or more layers to filter out candidates for this role, etc. The Supreme Court in 2011 dismissed these petitions outright. In Hebrew, we say threw them down the staircase. I don't know what the parallel in English would be. Dismissed this petition outright, said that there's no statutory basis for it whatsoever. The legal counsel of the government agreed with that and essentially argued on behalf of the government that there was simply no basis to require that the government deviate from the current statutory framework, et cetera, et cetera. One of the justices sitting on that 2011 decision was none other than Justice Yitzchak Amit, who today is the Chief Justice in our current. So fast forward to today, the Supreme Court had just issued a ruling. This is after the government tried to appoint recently a new civil service commissioner. And again, there's some drama and more background behind this, which I won't go into. Essentially, this ruling comes out and says, no, actually, the government is now compelled or obligated to adopt a competitive process, to adopt a process in which a committee, not necessarily subject to the government's selection, I mean, not even a committee that the government appoints, a committee pre-nominates, a committee selects a whole bunch of candidates from which the government is obligated to choose one, essentially rescinding the government's ability or power to appoint this very, very senior position. So these are the two recent major rulings that we have. I'll just say one more thing, which is kind of, I think, extraordinary. You have this really phenomenal reversal from both the legal counsel of the government and from the court on this issue of the civil service commissioner. And I didn't mention, of course, in both these cases, the Shin and the civil service commissioner, Justice Solberg was a minority opinion and obviously did not agree, a dissenting opinion. And he points out all these issues. But what's really extraordinary is especially in the civil service case, because it's such a blatant reversal from a previous from precedent, they just can't point to any reason, especially Justice Amit, any reason that they're just reversing their position by 180 degrees. And Justice Amit's explanation essentially is that he doesn't trust this government, which I think as a legal argument is just phenomenal. I mean, we can go into that in a moment. So sorry. So this was a very long.
It's a legal argument that has been accepted within legal circles. That's the issue. Or it's a quasi legal argument.
Absolutely.
That's being all right. So I just want to review the kind of outstanding features that you've mentioned so far, and then focus in on an aspect that I think we need to flesh out. right? So the fact that the court is able to even hear these cases is because all is justiciable and there are no proper boundaries to what the court can hear. The fact that the court can hear these cases brought, or rather the complaints brought by outside plaintiffs who are not in any way real parties to the case, is because standing is basically unimportant today, and at least at least in the cases relating to the High Court of Justice dealing with constitutional issues. And then within that, there's this issue of the panels, which otherwise would have been, in a more normal setting, would have been 5, 7, 9 justices for cases of this kind of profile. And then there's the substance of the cases themselves, where at the very least the Shabak director case should have been mooted by normal standards. And in the case of the Civil Service Commission head, there's been an actual reversal on substance. Have I got it?
Correct.
Okay.
Correct.
Thank you.
And setting aside that, of course, just simply on the merits, on the letter and spirit of the law and on precedent, the rulings are just completely unfounded. To the extent that we dignify such rulings with any measure of serious legal consideration, which I'm not sure that they deserve it, but it's manifestly obvious that there's just no genuine legal argument here to support these rulings.
And then as far as this being kind of a new step for the court, it sounds like it's a matter of scale, because on the one hand, the court is now effectively in charge of who can be in charge of the internal security apparatus, and also perhaps of the state's entire bureaucracy, according to the court. Okay, got it. But let's talk about the court for a second as far as appointments go, because that issue actually is an old one, right? The court's been invalidating appointments even of ministers since the 90s, and the government has been acquiescing. You could argue that there is precedent for such things. Talk to me about it.
Absolutely. So I think you're spot on in terms of the bigger picture here. And I think there's a sort of prima facie or like an initial argument about sort of this is more of the same. As egregious and outrageous as it is, this is kind of what we're used to in terms of the court's jurisprudence on appointments. And I want to dive into that. So I think there are 2 points here about the context and the big picture. One is what you mentioned. Another, which maybe we'll get to, is the sort of the culture war elements and slightly larger societal questions. But we'll come back to that in a minute. So let's talk about appointments in a second, and I'll try and explain both a little bit of the background and also why I think it's not only a shift in degree but also in kind. It's a genuine escalation, not just in scale. So as you said, since the early 90s, the court has developed a doctrine essentially controlling appointments throughout the entire executive government. It didn't actually start. The most famous case that sort of set this doctrine is called the Derry-Pinchasi case. It's a twin case, as people sort of for shorthand, they call it the Derry case or the Derry doctrine. And we won't go into the entire history, but basically the court decided that it actually decided this beforehand in the Eisenberg case, but I'm giving the general picture of the doctrine. Any executive appointment is subject to the judicial review on the basis of its reasonableness. So we're talking about appointments which are 100% valid in terms of any other legal standard, right? Legality, arbitrariness, corruption, procedural flaws, any other typical argument about the about the illegality of appointment, that's on the side. We're not talking about that. Purely on the question of reasonableness, the Supreme Court or any court essentially can invalidate any appointment in the executive government. Now, that's not. I'm glossing over some details here, and we'll get into some of them in a moment. We're not going to talk about too much about the reasonableness doctrine or the reasonable standard today. But just to be clear, this is not this reasonableness standard that anyone else might be familiar with from a foreign jurisdiction. This is what some call a balancing standard, where essentially the court asks, has the government or has the official correctly balanced the different factors? And if they haven't correctly balanced the different factors and considerations, then it is unreasonable. Of course, we understand that this is itself the essence of government. Governing is balancing in the way that the government decides to, right? The different factors and considerations. And as you know, of course, appointments, the power to hire and to fire, is the heart of governing itself, meaning there's very little essence and substance to the act of governing beyond appointing the people that you want to appoint to different positions. So putting that on the side, In 1993, the case is focused on the dismissal of government ministers. The Supreme Court compelled Prime Minister Yitzhak Rabin to dismiss two of his government ministers. And this was on the argument that it was unreasonable of him not to dismiss them. And then this doctrine essentially rolled on for years and years in various permutations. It did escalate every time. So essentially that case, the Derry doctrine, was a case about dismissal. It was about dismissing senior ranking officials. I should mention, of course, these are, again, cabinet ministers, elected officials, people who are also elected to the Knesset, meaning there's already an oversimplification about pretending that this is merely a question of executive power and executive decision making. And Professor Yoav Dotan, who's an esteemed Israeli scholar, points this out. And he says that the court sort of consistently pretends that this is a technical question of administrative law. It's as if they're reviewing, right, some municipal decision whether to grant a business license, and not, the most extreme, high-level questions of, within any constitutional order. They don't even treat it as a question of constitutional significance. So putting that aside for a moment. So this doctrine has sort of rolled on over the years, but it has sort of developed over the years. So originally it was about dismissing and compelling the government to dismiss officials. Then at some point it also became more dominant regarding appointments, meaning an initial invalidation or an initial prohibition on certain appointments. And I won't go into the history because it's very convoluted and complicated. There are many instances. We're talking about the most senior levels, right? Commissioner of National Police, Chief of Staff of the military. There's some other great examples. The Paklit Medina, the Chief Prosecutor of the Criminal Prosecution Service, promotions within the military. And of course, like I said, this comes up regularly, routinely for government ministers. So like the most high-level conceivable type of appointment in the executive government is routinely subject to judicial review on the basis of whether it's reasonable. Okay.
And
this has been the prior doctrine.
The government, I think, is basically always acquiesced to the court decision. I'm not sure where they've, really made a stand and fought for it.
Yes, that's an interesting question. In most cases, the government has not put up a serious fight, and it's not exactly clear. I think we'll get to this a bit later. Not exactly clear what that kind of fight would look like. There are some instances where they did something borderline. So I'll give you one example. Aryeh Deri, when he was reappointed, I'm going to say in 2022, I think, maybe 23.
That's right.
He was, right, Aryeh Deri was reappointed as a minister, even though the court had not ruled against it initially. But after he was appointed, the court ruled that he could no longer serve as a cabinet minister. I won't go into that. Extremely egregious ruling. I'm no fan of Aryeh Deri, but still a highly problematic ruling on its legal substance. So then what they did is that he joined the cabinet as an observer, like as on an observer status. And you could say like this is kind of like a finger in the eye of the court. It was sort of, well, he doesn't have a vote on the cabinet, but he's like for all intents and purposes a cabinet member. So I mean there are all kinds of little ways, but I think you're right that the government has not yet just full out flouted that kind of appointments decision by the courts. You could ask maybe, again, this gets kind of complicated, but like the Chief Justice of the Supreme Court is currently in a disputed position, meaning his role and his self-appointment as Chief Justice is currently not recognized both by the Speaker of the Knesset and by the Minister of Justice. So that hasn't had really any serious practical ramifications so far, but that might sort of indicate something of that kind of resistance.
I'm going to press pause. I know I opened this question, but now I'm going to pull back to where we were. And I just want to get to this question of, okay, so now we have this history and we've had an escalation each time, and this time it's different because
what's happening now?
And then I want you to bring it to what you mentioned about sort of the larger cultural picture.
Absolutely.
Okay.
So this is a major escalation, and now I want to go into why this isn't just more of the same. So why I think people are correctly regarding these two decisions as really, really significant development in the tensions or in the struggle, I should say, between the court and the elected branches. First of all, for the Civil Service Commissioner is just in a sense that just the degree of the reversal from the court is kind of shocking in the sense that In most cases, the court has some kind of, some kind of argument that it can latch onto that might be plausible to someone. And here the court is doing this is such a blatant reversal in terms of what it previously did. But more importantly, and this is where we get to the in kind versus in degree. Now the court in the Civil Service Commissioner case, we'll get to the Shabak in a moment. Civil Service Commissioner case, the court is now dictating the process of appointment. It's not just, and this is I think something which a lot of people are missing. It's not just saying this particular individual, the appointment of this particular individual is unreasonable or we don't approve of it. It is now dictating, and this I think it genuinely is unprecedented. The court is now dictating to the government what the correct process for appointments is for this role, which I think again is bizarre. You have much more senior roles who are appointed directly by the government, right? You have like the chief of the police commissioner and the chief of general staff and all these other roles, and yet this particular role, now the court is insisting essentially to mandate to the government how they appoint him, with again no basis.
It's a very important and strategic role. I mean, in terms of the government's composition,
with strategic ramifications and implications for the civil service.
Mm-hmm.
And obviously the court identifies it as such. Otherwise, it would not be insisting in the sense that the government to sort of, there's a phrase that I like from Lord Jonathan Sumption where he talks about the levers of power. And there's so much within the Israeli context where it's the court or the legal establishment putting more and more filters or barriers between the government, the elected government, and the levers of power, the actual ability to affect policy and government change and execute the governmental agenda, et cetera. And this is a great example. So that's a civil service commissioner. We already have a change in kind here. The Shabak is in some cases, I think, more extreme for two reasons. And the second I'll get into that ties into our other societal context. But even while we stay on the legal side, the court has never before, certainly not in a high-profile case, insisted that someone stay in their role. So I want to make sure that you understand the difference. It's one thing to say you can't hire someone, and then it's another thing to say you have to fire someone. In both these cases, you're actually preventing someone from serving in a role. You're preventing the government from having somebody serve in a role. Now, in the context of the Shabak, the court is saying, at least in principle, even though it says in theory it's all right, it's a moot case, whatever. But the court is, the government voted to fire Ronen Bar a month ago or whatever it is, or a month and a half ago. And I've lost track of when exactly it was. But
It was like
he's supposed to already be fired.
Yeah.
What's that?
No, maybe it was late March. You're right. I've lost track too.
Yeah, I think it was March. I think it was end of March. So this is unprecedented, and I think genuinely bizarre in the sense that you have the court telling the government that they must retain, with no legal basis in law. It'd be something else if the law gave some really specific reasons, right? There are certain roles in many democracies which the government cannot just fire at will, right? Classic example is like a central bank head or something like that, where there are all kinds of reasons why central bank head is typically not like an at-will government employee. Fine. This is clearly not the case. And we can get into the principled issues in a moment. But here the statutory law is unequivocal, could not be more clear. And yet the court insists that the government retain the head of Shabak and that he stays in his position despite the enormous breach of confidence or breakdown of confidence and trust between the head of the Shabak and the head of the government. And you have to think for a second. What does this mean? Like, imagine that the government just said, you know what? Imagine that Ronen Bar said, didn't say that he's retired, that he's resigning in whatever it was, mid-June or whatever date he gave. Which is also like, if you're resigning in mid-June, then just go ahead and resign. Like what, it's all kind of strange. But what is the government actually saying? Are you actually saying that the head of the secret police, the head of the state secret police, should stay in power in an absolute breakdown of relations between him and the government, absolute level of unprecedented levels of distrust between him and his civilian, theoretically, supervisory government without the consent of the government? We're talking about in the height of conducting war, right? The government is supposed to rely on the cooperation of this guy. They're sitting in regular intelligence update meetings. They're getting information from him. They're supposed to rely on getting updated information. And by the way, vice versa. I'm sure that he can't do his job in a good way if he doesn't trust the government to be completely straightforward with him in terms of their intentions or in terms of their goals or in terms of the information they're looking for. Even if he's the good guy in this story, and somebody was making this point, somebody I think on sort of on the supremacist side, on the activist side, was making this point. Even if Ronen Bar and the Supreme Court are the good guys in this story, the head of the secret police, the head of the state clandestine intelligence service, simply cannot serve in this role if he has lost faith of the government and there's no mutual faith there. One last point, which some people have made, which I think is relevant, putting aside the entire question of sort of politically motivated investigations and that kind of thing. We're not even going there.
That's its own several episodes, right?
Right, of which there are several, and there have been over the years, and this is not new. But the Shabak is also in charge, among other things, for the personal security detail of the prime minister and of all the government ministers. And this is something that I think is not sufficiently addressed. This is not like, let's say, the Secret Service in the U.S., which is like a separate unit. So imagine if the FBI was in charge of security for the president in the U.S., and at the same time, the president and the head of the FBI are in an unprecedented conflict and collision and completely lose trust, and the head of the FBI fails to resign. To what extent do you trust your own, the diligence of your own security, etc.? Okay, so we've said that. Yeah, go ahead.
Right. So we have about, let's say, 15 minutes max right now. I want to do the culture aspect, and then I want to ask about the court again.
Okay, so I'll be brief on the culture question, just because it is a large issue to unpack, and I think we can't do it justice by even by trying to dive into it. But very, very briefly, obviously, there is a context here of a significant culture war, for lack of a better term, between different groups in Israeli society, and that much is obvious. But one thing I think which is less obvious, certainly to a non-Israeli audience, is the relevance of Israel's armed forces and who dominates and controls Israel's armed forces. And to sort of back up a little for a moment to principle, right? Robert Dahl, who's like the greatest scholar of democracy in history and the greatest political scientist of the 20th century, he identifies some core preconditions for the existence and sustainability of democracy. And one of them is civilian control of armed forces, period. Like, if you don't have elected civilian control of armed forces, then your prospects of maintaining or having democracy are zero. And I think this is a fairly obvious insight to most people. And yet in Israel, we're now in a situation where more and more people, certainly from the legal establishment, even from the political opposition, are advocating this kind of, let's call it for a moment, to use the most generous term, a kind of autonomy, right? It's a word they use a lot. The autonomy, the independence of different armed services, including clandestine secret police, from government control, they sort of use the word political control, right, disparagingly, right? Political control means bias control, means serving all kinds of anecdotal interests, etc. And this is, I think, a genuinely frightening scenario for, I think, people that care about Israeli democracy, that care about Israeli stability, because that is a question that should be beyond debate. The armed forces must cede to the control of the elected officials. Here is yet another step, and this is where we're getting back to the Shabak decision. Here is yet another way in which we're having the judges support this idea that the Shabak, the state secret service, is supposed to enjoy this certain level of immunity and autonomy where the head of the secret service cannot be fired by the government if the government wants to. And then one last asterisk I put here, I'm sorry that I know this is very long, is that think for a moment, this is the head of the Shabak, this is the head of the Shabak who was there on October 7th and in the lead up to October 7th. In any other country, this guy would be on borrowed time, even if they kept him on for a little bit. There should be not a second's hesitation or any requirement to justify firing this guy. There's no question that the moment somebody says so, he's out of his job. And yet here we are, where he's still in his job months after he was dismissed by the government.
Okay, so the bench. So I had this really interesting experience in the UK a few years ago where I was trying to explain what I thought was clearly like the coming conflict, and I was talking to some UK barrister, and he goes, we've had tensions between our court and the government as well, but there are these backroom contacts, and the judges have sort of been let in on the fact that it's leading to a lot of tension that shouldn't be there, and so they're sort of self-restraining in response. And I found it very hard to communicate that here the situation at the time was already getting somewhat tendentious, and today, of course, we're at the point where, as you mentioned, the political leadership of Israel is not recognizing the court's own leadership. So I don't know exactly what the prospects are. However, I'm sure you saw that in the annual conference of the legal bar, there was Justice Yosef Elron gave a talk. He opened very clearly with what seems like a warning shot to the president of the court, where he said, look, without relating specifically to the last two decisions, the court has had this mega trend of increasing its power in constitutional decisions. And he also said al-chukatiyot, as in like even above constitutional decisions, which is something the court's been able to kind of wedge itself into somehow. And it's creating a discourse of extremes. And this is not what we should be doing. I paraphrase, of course. But the question arises, is it, there are supposedly conservatives within Israel's court. There's certainly some variety of opinion. Is there any way that the institution pulls back before this becomes an even bigger crisis? Talk to me about conservative judges.
It's a wonderful question in terms of the prospects for de-escalation. So sort of what is the likelihood that we actually have some de-escalation coming from the court, and whether that would happen, thanks to conservative judges, on the court sort of just being more aligned with maybe what the government is trying to do or whatever it is. Then, I know that these are two separate questions, and what you described in England isn't necessarily only just having conservative judges in power, but also a more institutional recognition of your own contribution to the situation, and an institutional decision to take a step back. So I guess I'll answer both together. I think, unfortunately, the prospect of conservative judges making the difference, or of the court, making that change on an institutional level, are unlikely, unfortunately. And I hate to sort of throw cold water on that idea for a few reasons. One is that even if the court was dominated by conservative judges, which is unlikely, and I'll explain why in a moment, it's unlikely that just a handful of unrestrained judges can undo quickly 40 years of judicial supremacy and its effects. And I don't think that just judges being a little bit more hands-off can compensate for some of the inherent fundamental flaws endemic to the Israeli legal system. But more to the point, I think there's a practical point here, is that most of the conservative judges, so to speak, on the court are not conservatives in any sense that we would typically talk about legal conservatives. That I don't want this to sound like a sort of purist perspective, or sort of a radical perspective where, none of the conservatives are conservative enough for me. And, they're all either, they're not, I don't know, they're like, if they're not the base, if they're not hardcore, card carrying conservatives, then they don't count. It's not that at all. I think, let's try and actually look at this analytically, right? I would say without getting too deep into what makes a judge conservative and let's say there are three ways to evaluate whether we think a judge is conservative or not, right? In the Israeli context, we can compare them to the sort of relative to the mainstream of conservative legal thought in Israel, right? What do most legal conservatives say? How do judges relate to that? So, and do conservative judges in Israel reflect the mainstream of conservative jurists or conservative lawyers or people on the conservative legal side, etc.? The answer there is not really, or not at all. I'll give you one really example. There's a really good litmus test, right? Most of the legal conservative movement in Israel believe that the court does not properly have the power to strike down legislation, ordinary legislation. Now, what you do with that is a different question, right? Do you stop doing that? Do you try and annul the original 1995 decision that recognized that authority or whatever? But, wake up any conservative legal scholar or practitioner in the middle of the night, right, and ask him, 1995 Bank HaMizrahi case, valid or invalid? They'll say invalid. Does the court have the authority of judicial review of legislation? Yes or no? No. So the reason I'm saying that is because you will be very hard put to find a judge, a so-called conservative judge in the Supreme Court that will say that. And I think most don't think that. I think the only exception is Justice David Mintz, who basically intimated that was his position in the reasonableness ruling. And so far, he has not sat on a single panel where he's voted to strike down legislation. So at least in theory, there is one. But one is not a very optimistic prospect. So at least here's one measure by which we know that the conservative judges do not reflect mainstream of conservative thought. Two, and we'll do this very, very briefly, is the way in which judges are appointed. And that obviously merits an entire different episode, which I'm sure one day you'll have about judicial selection in Israel. But, the basic question is, when so-called conservative judges are appointed, do they reflect the deliberate preferences and desire, right? Is this the pick of the conservative camp? And again, the answer in Israel is decidedly no. Because of the judicial veto, by which sitting judges essentially can decide who joins them on the bench or veto candidates, then and because these judges are at least historically, by and large, have been, since the Barack era, since the 1980s and 1990s, have all been activists. They've all been judicial supremacists, and their goal has been to get more activists, more radical activists and supremacists on the court, and their goal has been to block genuine conservative judges in the court, like Ruth Gavizon or others, who the court blocked. Any conservative candidate who successfully makes it to the court is, by definition, a compromised candidate. There's a great example right now, right? The government wants to appoint two senior legal scholars. One is Rafi Biton and the other is Aviad Bakshi. And the court is saying flat out, point blank, no. There's no room for compromise. There's nothing to talk about here. It's not like we'll get 2 of ours and you get 2 of yours or anything like that. The answer is no. These candidates cannot serve in the court, period, point blank, end of story. So again, by this measure, do conservative candidates on the court reflect the deliberate pick and desire of the conservative camp? Again, the answer is no. And finally, and I don't think we'll do a deep dive here, but in terms of substantive positions, right? In terms of like, what is the theoretical ideas that we think characterize a conservative judge or whatever it is, and maybe that has to do with like textual statutory interpretation or fidelity to the, to the meaning and the intent of the law, or maybe it's deference to government if you can, or all these other things. I think the answer is most of the so-called conservative judges would not answer those kind of broad universal tests of conservative justice, and these are people that I admire, these people that I respect. They're very capable judges, and they're smart and they know their stuff. It just doesn't make them automatically conservative. Is one of the easiest examples, and this is really easy, and I'll close with that. In terms of our evaluation of conservative judges, one of the easiest examples of this point is the reasonableness ruling. Okay, so in theory, 7 conservative judges voted to uphold the reasonableness amendment. We won't go into all that history and background. But what I'm trying to say here is that the primary argument there, one of the main questions in that case was, does the court have the power to invalidate constitutional amendments, constitutional provisions? In any country in the world, in virtually any country in the world, a judge that says that the court has the power to invalidate a duly enacted, right, a procedurally valid constitutional amendment would not be considered a conservative judge. Like it's just extremely unlikely by any sort of calculus or measure. You're not going to call a judge a conservative judge if he says that the court can just, based on arbitrary ideas of universal democracy, can strike down a valid constitutional provision. It's just not going to happen. Yet, only 2 out of 7 judges, meaning 2 out of the 7 so-called conservative judges on that case, flat out said the court does not possess this authority. This is something that the court cannot do. The other 5 conservatives, so-called conservatives, did not say that. And again, I'm not disparaging their conservativeness. They certainly are more conservative than other judges, and they might be, they are conservative in some ways. But this idea that the court now has this large conservative cohort, and you have this group of genuine stalwart conservatives, just doesn't hold up to reality. Then the last point I'll make here, which isn't about our evaluation of conservative judges, but you asked about sort of, what is the likelihood that this will bring to a de-escalation? Because maybe it could. Maybe if all these judges don't answer our definition of what is a conservative judge, maybe they can still lead this effort of sort of conciliation or de-escalation. And the answer is maybe when Justice Solberg becomes Chief Justice in 2028. I just wondering, that's a while away. That's more than 3 years away. A lot can happen in 3 years. The Assad regime fell in 2 weeks. Like, between now and, not to compare,
Right.
but, and I'll give you a spoiler. I'm not sure Justice Solberg is ever going to be Chief Justice, because the moment that Amit became Chief Justice, the judicial supremacists and the supremacist camp, in anticipation of Solberg being a Chief Justice, have started to argue that we need to change the method of electing a Chief Justice. And some argue that is in order to prevent the ultimate appointment of Justice Solberg as Chief Justice. But even putting that aside, most of the conservative judges are leaving the court very soon. 2026, 27, 28, they're dropping like flies. Most of the activist judges have a very long tenure ahead of them. They're staying until well into the 2030s. So even if we were to envision having this sort of strong conservative camp on the court who really want to do this détente or whatever, I don't really see it lasting in terms of the timeline.
So let's wrap up by asking you what you think happens now. Right, the government has put forth a candidate that they want to put at Shabak. This is David Zini. And as far as the Civil Service Commission, they also have a candidate. Do they fight? Do they not fight? What's the short term here, and what's the long term prognosis in terms of things reaching some kind of equilibrium?
Long-term prognosis for equilibrium requires another 3 hours of discussion. So I don't think I don't know. I don't know if I could do that. And genuinely, I don't know if I even have an answer.
This reminds me when we tried to start a podcast when you were still working with me, and then we had like 2 episodes, and half the episodes are just like, well, that's a whole other episode, but let me just.
Yes. No,
Yeah.
I'm a big believer in deep diving into, not necessarily justified, but big believer in the deep dive. But look, in the short term, just to sort of keep our viewers and listeners informed. So in the short term with the Civil Service Commissioner case, there are sort of two parallel developments. One is that the government, not the government actually, the Knesset initiated a private bill which is supposed to clarify in even stronger terms that the Civil Service Commissioner is supposed to be appointed by total government discretion, etc. And I think that's kind of a waste of time and completely useless. And we can say why in a moment. I mean, the court doesn't care about what the law says. They've made that clear in this ruling and in dozens of other rulings, and they can strike down a law that they don't like, and they can strike down a basic law that they don't like. So sort of playing with this in this framework as if, it's kind of the definition of insanity. There's also been a request for a rehearing. I won't go into the details, but Supreme Court decisions are not appealable, but there is a discretionary power or discretionary ability to have a rehearing with a larger panel. It's possible that there will be a rehearing. It depends on all kinds of technical details that I won't go into. And, potentially if there were a rehearing and you had an expanded panel, then in theory, like I said earlier, any expanded panel on the court would in principle vote the other way on both cases likely. So that could actually be reversed. Again, I don't know how likely it is with, when the chief, it's rare for a rehearing panel to completely reverse something that the Chief Justice is strongly against. There are other institutional considerations, like the Chief Justice can penalize you as a justice in a lot of ways if he's very unhappy with what you're doing, and that gets into a whole other conversation. So I think it is unclear. It seems like the government wants to insist on continuing what it does, but those two examples that I just mentioned, those are examples of playing within the legal framework, right? Amending the law or trying to get a different decision out of the Supreme Court. With the Shabak decision, it's a little more gray. The government has, the prime minister has announced that who his desired candidate is. And this is sort of a little bit, even though the court didn't quite say that he can't announce who he wants his candidate to be, but it did say, at least ostensibly, that he's in some kind of conflict of interest. And then in theory, the government, the prime minister is coming along and saying, this is who I want to appoint to this position, is kind of flouting that statement that he's in a conflict of interest. And of course, the LCG, the legal counsel of the government, has already sort of jumped up and said, no, you're in conflict, your decision is invalid, yada, yada. So we'll kind of see how that plays out. It's actually a good example. And this actually does go back to part of our conversation about institutional de-escalation. If anything, the court's current actions, especially under Chief Justice Amit, shows that the court is heading towards deliberate and conscious escalation. It's the opposite of de-escalation. I mean, the court has a very clear desire to escalate. And this is a great example, and this ties into what we're talking about with the Shabak, because the court could have easily said, if the problem was Benjamin Netanyahu's conflict of interest because of the Qatar investigation, the court could have easily, and it would have done this in a different scenario, it could have easily said, the prime minister should not be involved in the decision. The rest of the government can appoint the head of the Shabak in its own, in a separate resolution without the prime minister. Period. That's what would have happened in a different kind of in a different setting, but it obviously didn't. So the court made a very deliberate decision to come out with this much more extreme ruling. So in terms of prospects for change, it's very unclear. As always, we're in a tricky situation. I think after the reasonableness ruling, Professor Yoav Datan called Israel's current situation something of a constitutional dystopia. And we're kind of there, among other things, because the ultimate end game is unclear. Like, push comes to shove, if the government wanted to, it could do some flash legislation. And obviously, like I said, I think that's kind of ineffectual. The court the court ignores the text that is to say, which is sufficiently equivocal. I don't think there can be any clearer text which would make the court see things or do things otherwise. Even basic laws or constitutional legislation are now struck down by the court, essentially the drop of a hat on very, very flimsy grounds. So there's no real legal recourse within the legal framework of what the government and Knesset and elected officials can do. And so we are kind of in uncharted territory of what happens next. We will as we say in Hebrew. We'll live and see. I will just say regarding the long term, if you really want to talk about long term solutions, then obviously what the Israel Law and Liberty Forum is doing, I know I'm a little bit biased, but I think what the Israel Law and Liberty Forum is doing is of incredible importance to the long term solution in terms of both fostering debate and discussion on the merits between people, and that already is a tool for effective de-escalation, and that in itself is extremely important. And also the education and sort of enlightenment of the legal world in Israel, from the level of law students and all the way through lawyers and judges. That just makes a profound difference. It's a slow march, but I think if we're talking about long-term solutions, that's the big one.
You've left me feeling like I've talked to some kind of mix of like a professor and the Israeli legal Ben Shapiro. So just take that.
Those are the two greatest compliments you've ever given me.
I should have tried harder. Johnny, I
should say that's the most insulting thing. That's the most insulting thing you've ever said to me. No.
I hope to have you back both before your book comes out, after your book comes out. Really appreciate your time, and see you soon, I hope.
Thank you for having me.